Welcome to the Personal Injury Law Show. This is a show that talks about everything current in the law of personal injuries and of importance to you, the viewer. My name's Tony Carbone. I'm a personal injury lawyer of 30 years experience. With me tonight I've got Don Maffia, a partner in a law firm in car accidents. Good evening, Don.
Good evening, Tony. Good evening, yours.
And a senior lawyer, Ahmed, who deals in car accidents in a law firm. Good evening, Ahmed.
Good evening, Tony. Good evening, viewers.
Tonight, viewers, we're going to be talking about the risks of being a pedestrian on these roads and how the courts view you walking on the roads without keeping a proper lookout.
That's right, Tony. There appears to be a bit of a different view now from the courts about pedestrian cases.
Yeah, look, it's there's been a shift in the trends in terms of looking after these injured people, Ahmed.
There has been a shift towards the pedestrian having to keep more of a lookout, and if they don't, there seems to be a substantial effect on the damages they will receive.
Yeah.
But before we get onto that, what's in the news?
Well, fellas, there's been a lot of stories in the news. The first one, out in Ballarat, Don, there seems to be this constant problem with toxic waste. We had Visville, now they're talking about the...
Well, this is the land department using chemicals, I suspect, for spraying the weeds and all those things, which seem to have cause and connection, or appears to be some sort of connection to a cancer or like sort of conditions. And these chemicals, Tony, they've been used up from 1965 to 1995, so it's recent use as well.
It's just bizarre, isn't it,
Look, I think the government's done the right thing in this scenario in terms of making an independent inquiry and independent investigations. I'm sure we'll be hearing further from the government in this respect, and this story will develop over time.
Don, if you've got concerns about your health, or if you're developing some sort of, I don't know, condition, cancers, or if you have been diagnosed, what should you do?
Well, definitely seek medical treatment.
No, apart from that, I mean,
apart from that, look, you should inquire with obviously lawyers as well as your rights to compensation. I mean, this really seems a bit of a breakout like the asbestos, Tony. I mean, many years ago, asbestos was rife throughout the community, and now we see the effects of that and continue to see the effects of it. Now, this seems to have been a new wave of sort of conditions or in cases, chemicals which are causing some sort of cancerous condition problems.
Yeah, yeah. Viewers, we'll have to come back to this because I'm sure that the story will unfold in weeks to come. Don, there's this allegation that truck drivers are dealing drugs over their car radios and picking them up at their stops, the various stops.
The truck stops.
Yeah, truck stops.
Yeah, well, not only dealing, of course, using it as well, which is a very alarming when they're driving 64-tonne lethal weapons. There is incidences are increasing with drug users in truck drivers. In fact, Vic Roads has given numbers of 11,704 licences were suspended for drugs and speeding or taken away.
Ahmed, that's a pretty big number, isn't it?
That's a huge number, and I know we've dealt with this on the show before, but the ICE epidemic continues. The numbers do show that I think it is 1 in every 7 drivers tested positive.
And the things that arise out of this is not only is there criminal issues, Don, but there's also issues of insurance cutting out if you have an accident.
Look, in Victoria, we're lucky enough to have the TAC, was compulsory third-party insurer. So, you know, any person injured as a result of a truck driver taking drugs, they're still covered through the TAC system. But if we're talking about property insurance and things like that, if a truck driver is on drugs, or any driver's on drugs, it can void the old contract of insurance.
Well, let's say, for argument's sake, they write off a truck. The cost of replacing a truck is how much? Over 100,000 plus.
Definitely.
So there goes their livelihood.
Correct.
They'll be sued, and you know, a lot of problems, isn't there?
Oh, it does.
All right, we'll keep moving. Potholes on the road. I mean, this is some of the worst potholes I've ever seen. Ahmed, what's the story here?
So there's been an issue with increasing complaints against Vic Roads, or claims being made against Vic Roads for property damage to vehicles that have been subject to potholes or roads that have been in probably not great condition. The issue stemming is that the excess that Vic Roads has at the moment, which I believe is at about $1,330, is relatively high, and that means a lot of the claims that are made do not reach that extent, and therefore claims are being unpaid. The damage to vehicles is then the liability of the owners, who've got to then take it to a panel beater or whoever to make those repairs. So they're significantly out of pocket for the roads being in disrepair.
Don, it raises a number of issues, doesn't it? One, there's the damage to your car, but you'd hazard to guess that in a lot of instances, people could be running off the road.
That's right. Well, this threshold only relates to property damage.
Yes.
Which is a threshold, but now it works like an excess. And even if Vic Roads are aware of the pothole or the condition of the road and someone sustains damage to their vehicle and they're under the threshold, well, bad luck for the vehicle owners. So that's right, Tony. And to move away from property damage, if we look at the civil liability, the law tends to protect Vic Roads in this case, because Vic Roads are not liable for any personal injuries caused as a result of condition of a road or a hazard unless they had actual knowledge of it or they created the risk.
Under the Road Management Act, 2004 legislation,
correct,
they've still got an obligation to inspect the roads, don't they, Ahmed?
Yes, they do, and they often do have to keep records of that as well.
And generally, if they have a road management plan and they have some sort of system of inspection, that seems to be reasonable. It could be a defence as well. So it just looks like the law is siding with Vic Roads rather than the victims. But
let's say, for argument's sake, a particular problem road's been reported on more than one occasion. You'd think they can't rely on the sort of misfeasance and non-feasance to protect themselves, could you? That's right. So if they knew about the risk or the hazard, or they created the hazard, then they were liable. But otherwise, if there's a pothole that they weren't aware of and they did their inspections and it wasn't there at the time of the inspection, the law sides with Vic Roads or a road authority. And this is more reason why you probably need to get legal advice if something like this happens to you. Correct. All right, let's keep moving. Military trauma is on the increase. Defence chiefs are worried that in time to come there's going to be a lot more PTSD cases. Is this all the soldiers that have gone over to Iraq and the Middle East?
That's exactly it. That's been a catalyst for all of this. Unfortunately, for the countless men and women that have served their countries overseas, upon their return, the battle is not over. They are facing increased occurrences of PTSD, particularly at this stage, now that it's a few years removed from them returning. The Chief of Defence, Army generals have all acknowledged that this is going to be an increasing trend. However, the extent of it is not agreed upon at the moment. It is a significant worry, and the appropriate measures have to be put in place for these people returning to be looked after and diagnosed well.
Don, apart from the fact that they need treatment, are they entitled to compensation? You know, weekly payments?
Yeah, if they sustain an injury during the course of their service, yes, they're entitled to receive military compensation.
And what about common law lump sums? It's a lot harder.
Yeah, it's a lot harder than military comp acts. But look, Tony, this just goes to show we need to provide the support. Well, the government should continue to provide their support post-service as well. So these injuries are sustained during service, but the need comes after they come back from doing their service. And we see it time and time again. And an unfortunate thing, they're also turned to drugs as well. So ice is also rife throughout the military service as well, post-service.
Just recently I heard that there's nearly 100,000 ice addicts in the country, which is an extraordinary number, isn't it? It's becoming a common theme for us, Tony, so it's a bit worrying. Viewers, we've got to go to the sponsors break. Stay tuned. After the break, we'll take up this issue of pedestrians and what you should be looking out for. Viewers, welcome back to the show. Today we're going to examine the various culpabilities and liability of car drivers and pedestrians. Traditionally, Don and Ahmed, the courts didn't really look after a pedestrian if they don't look after their own well-being. Then we went to a point where pedestrians were starting to get looked after, and now there seems to have been a shift again where if a pedestrian isn't looking after themselves, the court takes off a huge chunk for what we call contributory negligence. So on that note, let's go to the first case. It's a 2014 Victorian decision of Kigetsis and Roach. Do you want to tell us the facts of this case, Ahmed?
Yeah. In this matter, it was a 24-year-old gentleman crossing at the intersection of Smith Street and Johnson Street in Collingwood, 9:20 p.m. at night. It's a well-lit night. He walks across the road.
Can I stop you for a minute? It's a very, very busy intersection, isn't it?
Definitely.
Yeah,
Definitely one of the more busy
Can
ones.
we agree on that?
Yeah, it is.
Yeah, it's always, traffic's
It's
very
not a big
slow.
intersection.
No, but it's always congested.
Yeah, that's
okay,
right.
okay.
As he's crossing in the first lane, there is a stationary truck with a stationary car behind it. The issue is he crosses while the pedestrian light is red, and he continues to cross across. Another vehicle travelling along the street comes through, doesn't have a clear vision of this man crossing the road, strikes him directly, head on. The man suffers a fractured shoulder, which doesn't require an operation, but has a very nasty knee injury, which requires multiple operations, as well as psychological trauma after.
Can I stop you there for a minute, Ahmed? Don, let's get the picture clear. He's crossing against a red man, correct?
Right.
The traffic's stopped anyway because it's congested.
No, there's the two lanes, so the left lane was clear.
Yep.
The right lane was by a bus and a stationary vehicle behind.
But the traffic wasn't exactly moving.
No.
Yeah.
And so the defendant, what the defendant says, the driver, he says, coming up to the intersection...
From the other side.
Lights were red, so slowing down.
Yep.
Sees the lights turn green, accelerates, goes across the intersection, and even admits that he wasn't even putting his foot near the brake when he was approaching through the intersection.
He had no intention of braking.
No, but the bus didn't move. And the evidence came out, the bus was stationed for at least 8 seconds at that time.
So he's travelling in the same direction as the bus.
Correct.
So how fast was he going? Is there any indication of speed?
I think it said around 30, I think,
30 to
kilometres.
40 kilometres an hour.
Sorry, 50 to 60 kilometres per hour.
Geez, that's fast.
Well, doing a speed limit, but for that time it was quite fast because he's going through an intersection. And then, like I said, just you've got to put a scenario, Tony, where there's a stationary bus. It has been stationary post the green lights or lights turning green for about 8 seconds and a car behind. And he's decided to drive right through the intersection without having any caution in terms of even being ready to brake if something came in front of his vehicle.
So it appears that he was negligent, correct?
Correct.
Yes. Ahmed, what did the court do in the first instance?
The subsequent finding was that the court found that there was 60% contributory negligence, which resulted in a damages award of approximately $1.1 million going down to approximately $450,000, which is a substantial discount on what the man would have received for his pain and suffering and future loss of earnings.
So if we look at what the plaintiff did, so the plaintiff's evidence was he was in a shop on a corner of Smith Street and Johnson Street.
Yes.
And he said that he was purchasing his cigarettes and whatnot. And then he saw that the light for the pedestrian lights were green, so he'd finished his purchase, walked out without looking at whether or not pedestrian light was red and just walked briskly across the street. So that's why the court says that in this case, the plaintiff must bear very significant responsibility for the occurrence of the accident. And I should also say that this whole trip of the plaintiff, he's going to Collingwood to get some heroin. Yeah. He was a drug user as well.
He was actually under the influence of drugs at the time,
Well, it doesn't say if he was, but he definitely was going to get a hit of drugs in Collingwood and stopped on the way to get a lighter or something at the shop. So that adds a bit of a twist to the story, but not really to how it all happened. I mean, how it happened was that he just walked briskly across the road without having to look at any vehicles coming across the red man and didn't see the car coming in the left lane.
Ahmed, do you believe that the contribution of 60% to come off, don't you think it's a bit too high considering that the driver was travelling at 50 to 60 kilometres an hour when the cars next to him and the bus were actually stopped? They weren't really moving.
I think the degree of contributory negligence is too high in this matter. I think a prudent driver would probably have his foot on the brake or ready to press the brake if you notice that there's a stationary vehicle next to you at a busy intersection at 9 p.m. at night in Collingwood. So I think there would have been some contributory negligence, but I think the degree is way too high in this matter.
Don, it almost gives me the impression that the driver was belligerent in his approach to this intersection, because he says in his evidence that my foot was nowhere near the brake. I had no intention.
He was just accelerating. Look, I think it's
Who knows if you didn't...
Look, circumstances would have been different if there wasn't the stationary bus. The stationary bus put the driver on notice that something was going on in that intersection, because the bus did not move even when the lights were green.
So you're saying that if it wasn't for the stationary bus...
Well, if it wasn't for the stationary bus, he just briskly walked across. Maybe it would change the result, but...
Well, you reckon he would have got less?
Probably, but the point is that the judge in this case, which was Justice Rush, he did put emphasis on the fact that the driver was on notice. You must keep a proper lookout, and if there's something going on ahead, something not quite right, as in not moving correctly or lights turn green and cars not moving, the driver's on notice. And that's the whole point. The driver has to be on notice, and by looking around the circumstances of what's going on. And that's where the plaintiff shouldn't bear a very significant portion of it. Like I agree with Ahmed, maybe should have been a bit less.
Look, I thought it was a tough decision. Yeah. Anyway, we'll keep moving. There's case of TNX Company Proprietary Limited Shivers, 2014 New South Wales decision. Do you want to briefly give us the facts of this case, Ahmed?
Yep. So this is a transport accident from 2008. A gentleman crossing the road across Market Street in Sydney, again a very busy street, the intersection of Market Street and George Street in Sydney, for those who are familiar. Gentleman crosses once again, though, at a pedestrian red light, and a taxi proceeds to then have a head-on collision with him. The interesting point of this is probably about 3 seconds prior to him crossing, two others had run across the road as well. He waits a few seconds, then crosses. The taxi nearly is a few centimetres away from colliding with the initial two people crossing the road, and then subsequently collides into him.
Ahmed, so this taxi driver's got full vision of people running across the road.
There's an acknowledgement that it's a busy time of the day. He's had two people just get past his vehicle. He continues to go through. He doesn't slow down. He's going approximately, I believe, 40 kilometres an hour, and he then strikes the gentleman.
Unlike the last case, in this instance, the driver can actually see the pedestrian. On that note, viewers, we're going to a sponsors break. We'll take up this discussion shortly after the break. Viewers, welcome back to the show. We're discussing this case of the fellow crossing the road, gets hit by a car, and he passed away. Now, the mother's brought a case against the driver, and the thing that traditionally the courts have done is looked after pedestrians, but based on that last decision and what eventually happened in this case, Ahmed, I'm starting to get the impression the courts are shifting again. In the first instance, what happened?
In the first instance, an award of approximately $800,000 was made. This was reduced by 40% for contributory negligence, leaving an award of approximately $480,000.
Don, I would have thought that in the circumstances where the taxi drivers had seen two people running across this intersection before the victim finally got struck, that's a fair decision.
Not in this circumstance, what, the 40% reduction?
Yeah, I thought that was a fair result.
Well, let me put something else in the mix, Tony. The taxi driver before the incident was talking to his passenger about jaywalkers. So he's well aware what was going on in the intersection.
What I'm saying is, I would have thought a 60-40 split in favour of the pedestrian, the deceased pedestrian, was a fair result.
Yeah, or even less, I would think. Because, like I said, the things of the driver, what the driver did, one, he was talking to his passenger about the pedestrians crossing the road. So he already was well aware. He already seen two cross. He sounded his horn, so he pressed it going there. So he's well aware what's going on. It's midday. It is a public holiday, but furthermore, even CCTV footage, he doesn't slow down. And the evidence came out that had he just slowed down a fraction, the accident wouldn't have happened.
Now, viewers, on that note, the driver appeals the decision, the case to the Court of Appeal in New South Wales, and it gets worse. What happened there?
It gets worse in the sense that the decision for contributory negligence or the new discount was now 75%. So we're looking at an award for $800,000 coming down to $200,000 and probably a discount of $280,000 from where they were at the decision at first instance.
Don, I find that absolutely extraordinary. Do you?
I do. And furthermore, going to add something else in the mix, the deceased had Asperger's as well.
Okay.
And even in that case, but the courts did not go on to consider whether that person's frailty or idiosyncrasy negates the contributory negligence. So look, it's not generally the case because when you apply the contributory negligence, you use an objective test.
Yes.
So the fact that it had Asperger's really didn't affect the fine of contrib. I think it should be considered further, and the courts may consider it further. I would have appealed
this to the High Court. I would have sought leave to go to the High Court.
It's pretty high.
Traditionally, the High Court's looked after pedestrians more than the driver, who's said to be driving a dangerous weapon or lethal weapon.
You know, if we look at the case that we discussed earlier, the one in Victoria, where 60%, and those circumstances were a little bit different. It was dark. There was the sight of the driver's view would have been obscured somewhat by the bus. Well, this had clear view. Okay. He saw it. He purposely drove through the intersection knowing full well the amount of pedestrians on the road and the fact that he just missed two pedestrian. He should have slowed down. He just kept putting his foot down.
Viewers, I'm not advocating that you as pedestrians shouldn't keep a proper lookout for your safety, but what I am saying is the court's views are changing. Yeah. Now, on that note, Ahmed, tell us the facts of this case of Casey and TAC. 28th of February 2009 is when this incident occurred.
Yep. And this is a decision from earlier this year. The circumstances are as follows. A gentleman and two of his work colleagues leave work. They get in a car to go to a cafe, I believe. As they're now walking across the pedestrian light, the gentleman in question says the pedestrian light is green. He walks along and then gets struck by an unidentified, unknown vehicle that's just described as a big green car. Now, at first instance, the jury found that there was no negligence in this matter. The matter was then appealed.
Can I stop you there for a minute? Don, because there's no, the car wasn't identified, you can still proceed with a claim, can't you?
Correct. So we're saying unidentified vehicle, the driver drove off. That's the allegation. Yeah. And in Victoria, the TAC, if you put them on notice, they can indemnify the unknown vehicle, unknown driver.
Wouldn't there be a presumption that because the driver's driven off, that the inference is that he was negligent? He or she?
Well, first we have to prove that the incident happened. And then secondly, yes, that's right. And I think that's the whole issue. This case at first instance proceeded before a jury of 6 people. So we don't know the reasons given.
But Don, it's highly likely you got hit by a car.
Well, well, yes, but the problem is that in this case you had the plaintiff who had a lot of credit issues, in the sense that he had prior form, he's been charged with obtaining financial advantage by deception, so all dishonesty events before, and I think somewhat afterwards as well, but I'll check that. But also the 2 witnesses that he was with.
3 witnesses?
Well, yeah,
3
for himself.
3,
2 of them did not go to court to give evidence.
Ahmed, that would weigh heavily against him, wouldn't it?
I think that's got red flags all over it. If you've got issues, or if they're challenging a person on their credit and issues with that, and then you raise the fact that there were no witnesses, or the witnesses didn't come forward to give evidence at court, even though they were his work colleagues, look, I think alarm bells ringing on that.
And it's an adverse inference. So the jury was open to the jury to accept that the reason why they didn't attend court to give evidence was because whatever evidence they were going to give would not help the plaintiff. That's the inference you can take.
So this fellow's past history weighed heavily against him?
Yes.
And yet, if this was a criminal case, the past history is not relevant until he's found guilty.
That's right.
It's a bit harsh.
It depends on, look, obviously with the Evidence Act and the New Evidence Act, it depends on what purpose it's used for. So if it's going to use for tendency to be dishonest, there's a lot of procedural evidence act things have to go through, or if it goes to credit, it's very limited. So it really depends on what it can be used for, Tony, the prior convictions.
Look, if you have a look at this fellow's past background, it's hard to really believe anything he says. 4 counts of fraudulently obtaining benefits from work authority. The surveillance doesn't support his evidence. You know, he doesn't give a proper account of what he did post the accident in terms of work. False declarations on certificates of capacity. Failed to declare any income tax.
Yep.
Inconsistency in his histories. A lot of marijuana use. I mean, the guy's not exactly a picture of...
Correct. I mean, one of the things that he said is that before the accident, at the time of the accident, he was earning X amount of dollars, which was all well and good, but then when they call for the tax returns, he hasn't declared that amount of money. So that also can always heavily weigh against anyone.
The reality is the jury didn't like this bloke. Is that a fair comment?
Yep, I think that it's agreeable.
Well, that's our point. I mean, this is a case where it's his story. He's saying, I was hit by a car, I've had all this treatment. Right? And then a jury just said, no, there was no negligence, which means didn't accept anything that the plaintiff
Just
said.
Quickly, do you think a judge alone would have looked after him?
I think so in those circumstances. I mean, being in front of a jury is a lot more unpredictable, so maybe there would have been a different outcome.
Don?
I totally agree. I think a judge would have given a different outcome. In this case, the jury went down to the jury verdict, and again, juries don't give reasons, and they just must have dismissed everything he said.
Ahmed, thanks for coming on board. Don, always a pleasure. Viewers, thanks for watching. Stay tuned for future episodes. Go to our Facebook and Twitter and the other social media sites, and always remember to stay safe.